The courtroom of the Supreme Court was completely filled with a tense, hushed silence that seemed to reverberate throughout the chamber. At the center of this quiet, focused atmosphere, Congresswoman Jasmine Crockett stood confidently at the lawyer's table, her posture showing her readiness and calm resolve. Despite the interruptions from Justice Samuel Alito, who had spoken up 3 times within just 5 minutes, Crockett maintained a steady and unwavering voice, demonstrating her command over her words even as tension grew in the courtroom. For many months leading up to this moment, the conservative member of the judiciary had been engaging in increasingly provocative and controversial public speeches, which often stirred heated debates about the role of judges in modern society. These remarks had sparked widespread speculation about whether such jurists should actively express their personal views or remain strictly impartial, especially in politically sensitive cases. Today, as Crockett presented her legal arguments in a case that could decisively influence voting rights across the nation, Justice Alito appeared visibly annoyed and increasingly impatient. His previous remarks indicated a growing frustration toward her careful and precise analysis of the state's stance, which he dismissively dismissed by declaring, "That's not what the Constitution says," before cutting her off mid-sentence, an act that only heightened the palpable tension in the courtroom. The room's visitors, a mix of legal experts, journalists, and civil rights advocates, held their collective breath as Crockett paused momentarily after being interrupted, her face showing unwavering determination as she made eye contact with the justice. With deliberate calmness, she opened a leather folder that had remained shut until that precise moment, carefully removed a single document, a legal brief, or perhaps a constitutionally significant excerpt, and began to speak, her voice resonant and measured. Her tone immediately commanded the room's attention, and the words she uttered in that instant carried a weight far beyond the few seconds that followed. The next half-minute did not merely silence Justice Alito, it revealed a profound truth, one that would resonate across the American legal landscape for many years to come. Prior to this pivotal turn in the proceedings, Congresswoman Crockett had already established herself as a formidable legal thinker well before she took her seat in Congress. Her extensive background included years working as a public defender, advocating fiercely on behalf of the underrepresented, and serving as a civil rights attorney specializing particularly in cases related to voting rights. Her deep understanding of constitutional law was a result of years of experience, those years giving her insights that most elected officials seldom possessed. Despite her transition into legislative duties, Crockett had preserved her law license, regularly taking on cases of exceptional constitutional importance. Among her interests was the challenge to restrictive and potentially discriminatory voting laws enacted by certain states, cases that tested the core principles of voting fairness and constitutional protections. Meanwhile, Justice Samuel Alito had been increasingly making headlines, but not always for reasons that inspired confidence in his impartiality. At a recent event hosted by the Federalist Society, he had made remarks casting doubt on the recent expansions of voting rights, raising eyebrows among legal circles and observers about whether his opinions might influence his judgments in cases like the one currently before the Supreme Court. Several complaints about his ethical conduct had been formally filed. However, the court's lack of a binding, enforceable ethics code left many of these concerns largely unaddressed. In a speech delivered just 3 weeks earlier, Alito had remarked that safeguards of voting procedures, some of which many viewed as essential for election security, were, in his words, not what the framers intended. His statement implied that efforts to make voting processes more secure could be perceived as discriminatory or unfair, a viewpoint that puzzled many legal scholars familiar with American constitutional history. These remarks received sharp criticism across the political spectrum, with many arguing they suggested a prejudgment of cases that might come before the court in future terms. Behind the scenes, Crockett had been diligently preparing not only her legal arguments, but also conducting thorough research into the historical and constitutional context of the very provisions Alito claimed to be defending. As both a member of Congress and a seasoned attorney, she brought a rare and valuable perspective to the intersection of constitutional law and practical governance. In the courtroom, the atmosphere was electric, filled with legal observers, leaders of civil rights organizations, journalists documenting every moment, and advocates eager to see how the court might rule on such a crucial issue. The Chief Justice, recognizing the importance of the case, had granted extra time for arguments, knowing that a decision on this matter could shape the future of voting rights for generations. As Crockett approached the podium to present her case before the court, a murmur of anticipation ran through the chamber. Many attendees, observing her poised demeanor, expected that Justice Alito, renowned for his aggressive and often confrontational style of questioning, would dominate the proceedings once again during this session. Given his reputation for probing legal arguments with sharp precision, many assumed that he would steer the discussion in a manner that highlighted his critical stance, thereby emphasizing the increasingly polarized nature of the Supreme Court's deliberations in recent times. The courtroom was set for what appeared to be yet another chapter in the ongoing saga of partisan clashes that had become an almost defining characteristic of the court's latest era. As Congresswoman Crockett began her oral argument, the atmosphere inside the chamber grew noticeably tense. An electric sense of expectation hung over everyone present. Unlike some of her predecessors, whose arguments and presentations had, in the past, been thrown off course or diminished by Justice Alito's persistent and probing questions, Crockett proceeded with confidence. She launched into her speech by recounting a tangible, human story, a narrative illustrating how the voting restriction law under scrutiny was affecting real people in real situations. Her tone was calm yet assertive, aiming to connect the abstract legal principles to the tangible consequences faced by ordinary citizens. She addressed the bench with clarity and composure, opening her remarks by stating, "Mr. Chief Justice, and may it please the court, the fundamental right to vote forms the very backbone of our constitutional democracy. It is the cornerstone upon which all other rights are built." In this way, she immediately underscored the importance of the issue at hand. She then pointed out a troubling fact. When last November, approximately 53,000 eligible voters in Jefferson County were effectively barred from participating in the electoral process, this was not merely a statistical anomaly or an isolated incident. Instead, it represented a profound failure within the fabric of the constitutional guarantees that are supposed to protect every citizen's voting rights. Her words delivered a sobering reminder that such disenfranchisement was, in essence, a tragic failure of the system designed to uphold equality and fairness in elections. As she laid the emotional groundwork by emphasizing these human stakes, several justices leaned slightly forward in their seats, signaling their acknowledgement of the gravity of her points. Once she had established the profound impact on individual lives and the broader democratic process, Crockett shifted seamlessly into a more technical legal analysis. She explained that the state government, through its arguments, claimed that Article 1, Section 4 of the Constitution bestows upon state legislatures unlimited authority to establish rules and procedures for elections. However, she challenged this assertion sharply, insisting that such a claim neglects both the explicit protections offered by the 14th Amendment and the historical context originating from the era of Reconstruction, which had sought to restrict states' powers in protecting the voting rights of all citizens. During her explanation, Justice Alito interrupted her with a tone that seemed dismissive, attempting to dismiss her arguments outright. She responded carefully, maintaining her composure despite the interruption. With clear confidence, Crockett clarified, "Justice Alito, I am not disputing the existence of constitutional authority, but I am advocating for a comprehensive reading of the entire document. The plain text of Article 1 on its own is not the whole story. The Reconstruction Amendments, the 14th and 15th, introduced significant limitations on state authority, fundamentally reconfiguring the relationship between federal and state powers concerning voting rights. She continued, emphasizing that understanding these amendments within their historical framework was crucial. Crockett explained how the 14th Amendment's guarantee of equal protection and the 15th Amendment's prohibition against voting discrimination precisely curtailed some of the state powers initially granted by the Constitution. She referenced debates from the Reconstruction era and pointed to judicial precedents, earlier Supreme Court decisions, that upheld these limitations. Justice Elena Kagan listened attentively, nodding with appreciation at the historical context Crockett provided. Justice Brett Kavanaugh took notes, perhaps recognizing the strength of her legal arguments rooted in history and precedent. Crockett then shifted her focus to address the core issue of the voter ID provisions under challenge, specific laws requiring government-issued identification for voting. She argued that these provisions, in practice, placed unnecessary and unfair burdens on minority voters, who often faced obstacles such as lack of access to required identification documents or difficulties in meeting new requirements. Before she could elaborate further, Justice Alito interrupted again, asserting confidently, "These are merely minor inconveniences, counsel, not constitutional violations. Every election regulation involves some degree of burden. Unless there is clear evidence of deliberate discrimination, such policies fall within the lawful scope of state authority." He emphasized that unless the plaintiffs could prove intentional discrimination, these regulations should be considered legitimate exercises of legislative power, rather than unconstitutional acts. Remaining calm and respectful, Crockett responded without hesitation. "With respect, Justice Alito, the Supreme Court has established, notably in the case of Anderson v. Bartlett, that regulations which impose an unfair or disproportionate burden on the fundamental voting rights must be justified by substantial and legitimate governmental interests, regardless of whether discriminatory intent can be directly proven. Even absent open discrimination, policies that hinder the right to vote in a manner inconsistent with constitutional protections cannot be simply dismissed as minor inconveniences." As her words concluded, it became evident that Crockett's strategic approach was rooted in a deep understanding of constitutional principles, historical context, and the importance of safeguarding voting rights against policies that, in practice, undermine equality and fairness. Her argument reflected a firm belief that protecting the right to vote transcends ordinary legislative discretion, insisting instead on a careful and nuanced review of how specific laws align with the core protections enshrined in the United States Constitution. The compelling evidence we have meticulously presented clearly illustrates that the concern of the state authorities regarding the prevention of electoral fraud is not something arbitrary or superficial, but rather an inherent and undeniable aspect of the legal and constitutional framework. It is a matter that is fundamentally self-evident, requiring no further justification or elaboration. During the proceedings, Alito, displaying visible signs of impatience, interrupted for the third time, his frustration becoming increasingly palpable. His repeated interjections reflected a growing impatience to express his viewpoint, which seemed to lean towards a minimalist interpretation of constitutional authority. It is important to remember that the Constitution does not promise or guarantee convenience or ease of implementation. Rather, its primary purpose is to delineate the distribution of powers among various branches and levels of government. To put it plainly, Congresswoman, the Constitution assigns specific authorities to different entities, and in the present context, that authority predominantly resides in the state legislatures. The emphasis on her congressional title, rather than her role as a member of the local or state council, did not go unnoticed by court observers, who interpreted this shift as an unusual break from standard courtroom protocol. Such a move appeared deliberately designed to underscore her political position rather than emphasizing her role as a lawyer or legal expert, which might focus more on substantive legal questions than political clout. Crockett, maintaining composure and unwavering resolve, paused briefly before fixing her gaze directly on Justice Alito. Her expression conveyed steadfastness, and her words resonated with clarity and assurance. She responded, emphasizing that the Constitution, esteemed and revered as it is, primarily functions not just as a document for the distribution of authority among federal and state entities, but also as a safeguard, a framework designed to impose necessary limitations on that authority. Its core purpose is to shield fundamental rights from potential overreach, to ensure that the power granted by the Constitution is wielded with restraint and accountability. However, since Alito's line of questioning delved into the very intricacies of the constitutional design, Crockett believed it was appropriate and indeed necessary to delve deeper into the historical record to shed light on the original intentions behind the constitutional amendments, especially those that affected electoral rights. She then carefully opened a leather-bound folder that had remained closed until that moment, revealing a carefully curated selection of historical documents. With deliberate care, she retrieved a single sheet of paper, an original source document, and held it up for everyone to see. I have taken the liberty of researching the primary sources that informed the drafting and subsequent ratification of the Reconstruction Amendments, particularly the amendments related to the powers of the states concerning elections, Crockett explained. Turning to Justice Alito specifically, she continued, "You have suggested repeatedly, both during today's proceedings and in various public statements, that the original understanding of the Constitution granted states almost boundless authority over electoral procedures and voting rights. That assertion, I believe, requires a closer examination of history and the actual debates that took place during those formative years." She then lifted the document, which had various sections highlighted for emphasis, making it clear that this was a key piece of evidence. She pointed out a transcript from the congressional debates of the year 1869, when Congress was actively discussing the passage of the 15th Amendment. This amendment was primarily designed to prohibit racial discrimination in voting, and Crockett emphasized that it was deeply rooted in the intent of the framers. Senator Oliver Morton, one of the principal architects of the amendment, explicitly declared that its primary purpose was to place the power of protecting the right to vote in the right hands, the hands of the federal government, where it rightfully belongs, rather than leaving it in the uncertain and often unworthy discretion of individual state legislatures. Her voice carried the weight of authority, as she quoted, "The purpose of this amendment is to affirmatively delegate the responsibility for safeguarding voting rights to the federal government, which has shown itself more capable of maintaining fairness and justice than states that have repeatedly demonstrated their propensity for neglect or discrimination." A profound silence filled the chamber at her words, an atmosphere thick with contemplation and realization. Justice Alito, shifting slightly in his seat, appeared momentarily contemplative as Crockett pressed forward. "Moreover," she added, "during the same debates, Representative James Garfield, who would later serve as president, emphasized that the time had come for a constitutional principle to be established that would override any state regulations that unnecessarily burden the exercise of the franchise, regulations based on conditions that are not intrinsic to the act of voting itself." Crockett turned to a second page within her folder, indicating further evidence. Most pertinent to this case, Crockett pointed out, was the statement by Senator William Stewart, who played a significant role in drafting the language of the amendment. He directly addressed concerns about whether states could impose procedural hurdles so significant that they effectively nullified a citizen's right to vote. She read aloud from the transcript. "We are establishing not merely a negative prohibition against explicit racial barriers, but also an affirmative principle that the right to vote must be practically accessible to all citizens, regardless of their social standing or economic position." Her voice was firm yet steady, conveying a clear message about the evolution of constitutional principles, from merely forbidding overt discrimination to actively ensuring accessibility. Several justices, including Chief Justice Roberts, leaned forward in their seats, keenly examining the documents Crockett had handed to the clerk for distribution. The atmosphere in the courtroom was tense with concentration, as everyone sought to grasp the historical assertions being presented. Crockett's careful presentation aimed to clarify that the original intents behind the amendments had been explicitly to grant a broad and robust scope of federal authority over electoral matters, especially to protect voting rights from discriminatory barriers, whether overt or covert. Justice Kagan shot a meaningful, deliberate glance towards Justice Stowe, a glance that conveyed more than words ever could. It was a silent signal, a moment of shared understanding, indicating the gravity of the discussion unfolding before the court. These exchanges are not mere formalities or fleeting gestures. They encapsulate the tension and stakes involved in interpreting the Constitution's most pivotal provisions. Meanwhile, Justice Alito, listening intently, continued with her thoughtful remarks, her voice gradually growing in conviction and clarity. She pointed out that the sources Crockett referenced were not obscure or obscurely located. These were explicit statements from the very individuals responsible for drafting the Reconstruction Amendments. These amendments, deeply woven into the fabric of our constitutional history, are the same foundational principles that Justice Alito and her colleagues often invoke. They are the framers' own words, carefully recorded and preserved in the historical record, directly contravening the narrow, restrictive interpretation that Crockett was advocating. This view, Justice Alito emphasized, was not just a matter of scholarly debate, but a stark contradiction to the original intent expressed by those who wrote the amendments, as well as in their subsequent public statements and ratification debates. Furthermore, the justice highlighted that these words, plain and unequivocal, serve to challenge and dismantle any attempt to construe the amendments narrowly or technically. Justice Alito's face visibly tightened, a sign of her discomfort and recognition of the implications of her opponent's position. A fleeting flicker of unease crossed her features as she comprehended the potential consequences of ignoring the historical intent encoded in these texts. She leaned slightly toward her microphone, prepared to respond, but Crockett seized the moment to press on, her tone measured yet resolute and imbued with a quiet authority. While others might veer into side issues or less pertinent arguments, Crockett maintained focus, asserting that the historical record, beyond any doubt, is stark and unmistakable. She pointed out that Congress, during the Reconstruction era, deliberately aimed to curtail the discretion granted to states over voting procedures. This was not incidental, but intentional, stemming from a keen awareness that seemingly neutral regulations could be exploited as tools to suppress certain voter groups. The framers recognized that race-neutral rules could conceal discriminatory practices, and so they took proactive measures to prevent this. She explained further that Congress's purpose was not merely to ban explicit acts of discrimination, such as outright denial based on race or ethnicity, but also to establish a federal interest in ensuring meaningful voting access. This was an affirmative commitment embedded into the law, designed to protect the voting rights of all citizens against procedural barriers that could be used as disguised forms of disenfranchisement. Turning her attention specifically to the facts of the case, Crockett highlighted a troubling disparity. In Jefferson County, a startling 83% of voters who had been denied ballots under the challenged law were members of minority groups. In stark contrast, minorities constituted only about 34% of the county's overall population. This statistical mismatch, this glaring inequality, alone would have been enough to provoke outrage among the framers of the 15th Amendment. Those original architects explicitly rejected the idea that states could leverage procedural mechanisms, such as literacy tests, poll taxes, or other hurdles, to achieve the same result as outright discrimination. They believed that using such mechanisms to suppress voters was morally and constitutionally unacceptable, even if cloaked in neutral language. Justice Barrett, who had been observing the proceeding quietly up to this point, finally interjected, addressing Crockett directly. She acknowledged the compelling nature of the historical sources presented and posed a thoughtful question. How should these sources influence the standard of review that courts apply in this case? This was a critical interrogation, inviting Crockett to clarify how historical intent should shape contemporary legal analysis. Crockett responded with measured confidence. She explained that these historic sources make clear that, when evaluating voting laws, the court should exercise heightened scrutiny if those laws lead to substantial disparities in ballot access. This principle applies regardless of whether the lawmaker's original intent can be proven definitively. The Reconstruction framers understood, she argued, that the right to vote is foundational, an essential safeguard that preserves all other rights. Because of this vital importance, voting rights deserve a special tier of judicial protection, particularly when procedural rules or regulations disproportionately hinder some groups while leaving others unaffected. These protections are rooted in the recognition that voting is not merely a political act, but a fundamental human right that sustains the entire democratic fabric of society. Justice Alito, seeking to steer the discussion back to a more procedural focus, attempted to reorient the debate. She commented that the historical records Crockett cited, while interesting and relevant, might be seen as mere footnotes, valuable context, but not directly overriding the clear language of the Constitution. She emphasized the text of Article 1 of the Constitution, which grants Congress certain powers and responsibilities over election laws and procedures. With all due respect, Justice Alito suggested, these historical sources should not overshadow or diminish the straightforward language of the constitutional text. However, Crockett responded calmly but firmly, asserting that these sources are far from mere footnotes. They are the authoritative explanations of the original meaning of the Constitution, notes crafted and ratified by those who wrote, interpreted, and approved these amendments. These sources, she insisted, speak directly to the relationship between the powers granted under Article 1 and the additional constraints established later through the Reconstruction Amendments. These amendments, especially the 15th Amendment, were designed precisely to impose limits on state authority, particularly in the realm of voting rights. They were intended to prevent states from using procedural tricks or discriminatory practices that could undermine the fundamental right to vote. As Crockett progressed, she addressed her final major point in the argument, emphasizing that the Reconstruction Amendments fundamentally changed the constitutional landscape of the United States. Instead of merely complementing existing constitutional provisions, they introduced new boundaries, constraints that limited state power in ways explicitly tied to the protection of voting rights. These amendments, she explained, effectively created a new framework that placed limits on state sovereignty, especially in matters concerning racial equality and voting access. To interpret Article 1's powers as though these historic amendments did not exist, she stated, would be a departure from the original constitutional design. It would be an act of selective constitutionalism, an approach that cherry-picks what to follow and what to ignore, instead of adhering to the totality of the constitutional text and its history. The phrase she used to conclude her argument, "This is not textualism or originalism, it is selective constitutionalism," resonated softly yet powerfully within the chamber. It served as a reminder that constitutional interpretation must be grounded in the full context of history, text, and purpose, rather than cherry-picked snippets that suit a particular viewpoint. Her words hung, weighted with conviction, as the chamber absorbed the significance of her reasoning, emphasizing once again that the original framers and ratifiers intended their amendments to serve as lasting constraints on state power in the vital area of voting rights and racial equality. In the quiet stillness of the courtroom, several law clerks who were seated quietly in the back rows visibly reacted to the unfolding moment, their expressions a mixture of surprise, curiosity, and admiration. Justice Clarence Thomas, known for his minimal speaking during oral arguments and his tendency to listen intently rather than engage verbally, displayed a subtle but unmistakable sign of response. He raised his eyebrows slightly, a gesture that conveyed his interest, and perhaps even a hint of admiration for what was taking place before him. This small gesture did not go unnoticed by those present, as the atmosphere in the chamber grew charged with anticipation. Chief Justice John Roberts, who held the reins of judicial decorum, and understood the gravity of this particular hearing, recognized the significance of what was happening. Sensing the importance of the moment, and perhaps wishing to ensure that the parties involved had enough time to fully present their arguments, Roberts made a rare decision. He graciously extended the time allotted to Crockett, one of the attorneys, by an additional 5 minutes. This was no ordinary extension. It was a deliberate and meaningful gesture that indicated the court's deep engagement with her presentation. Such overt flexibility was seldom granted, signaling that her argument was resonating strongly with the court and that her points deserved thorough consideration. With the additional time now at her disposal, Crockett reconnected her discussion with a series of historical insights, meticulously expanding upon the context surrounding the legal issues at hand. She drew a clear line between past and present, linking the historical struggles for voting rights, embodied in the Reconstruction Amendments, to the specific evidence involved in this case. Her methodical approach demonstrated how the state's voter ID law was not merely a practical policy matter, but, in fact, imposed procedural burdens that directly contravened the fundamental principles established to protect voting rights in the aftermath of the Civil War. She explained that these burdens closely resembled, in their nature and effect, the kind of restrictions the Reconstruction Amendments, particularly the 15th Amendment, aimed to eliminate. In her closing remarks, Crockett looked directly around the full court, making eye contact with each justice, and emphasized an essential point. She declared that this case was not simply a matter of choosing between convenience and security, as some had framed it. Instead, it was about affirming the constitutional promise embedded in the Reconstruction Amendments, a solemn commitment to safeguarding the right to vote for every citizen, regardless of race, socioeconomic status, or economic power. As her allotted time came to an end, Crockett gathered her documents carefully, a final act of professionalism amid the tense stillness that had fallen over the courtroom. Her voice, now slightly more resolute, delivered what would be remembered as a powerful closing line, one that struck a chord and left the entire chamber in a state of stunned silence. She conveyed, in no uncertain terms, that the framers of the 15th Amendment, who had fought so courageously to secure voting rights for formerly enslaved people, would recognize the current realities of Jefferson County today. Her words posed a profound question: whether this court possessed the constitutional courage, the moral and legal backbone, to perceive and confront these realities as clearly as the framers did more than a century ago. A collective gasp swept through the chamber, as if a wave of realization had finally taken hold. Justice Stephen Breyer, known for his contemplative style, sat motionless, the weight of her argument clearly affecting him. The historical evidence Crockett presented had not only challenged the questions she faced in this case, but also undermined some of the positions Justice Breyer had publicly advocated over many years, forcing him to reconsider previously held assumptions. Meanwhile, other justices exchanged glances, silent communications that conveyed recognition of the pivotal nature of what they had just witnessed. Their expressions reflected a mixture of reverence, reflection, and tentative acknowledgement that an important shift was underway. As Crockett returned to her seat after her compelling presentation, the customary murmur of the courtroom, often heard after a strong or controversial argument, was conspicuously absent. Instead, the chamber remained shrouded in a deep, contemplative silence, as if the entire room was collectively absorbed in digesting the gravity of her words. This was a rare, almost historic moment. The convergence of constitutional history, rigorous legal argumentation, and moral clarity aligned with such force that it seemed to illuminate the very foundation of the court's understanding of voting rights. The impact of Congresswoman Crockett's historic appearance before the Supreme Court extended far beyond the immediate case. It sparked a significant shift in constitutional discourse surrounding voting rights, injecting new energy and perspective into ongoing debates and judicial strategies. Her compelling argument not only challenged existing interpretations, but also inspired renewed respect for the importance of historical evidence in constitutional interpretation. Within days, legal scholars and prominent publications began analyzing her presentation in detail. Many focused on what came to be popularly called the Crockett Brief, a comprehensive written submission that thoroughly elaborated on the historical evidence she had introduced. This document became a subject of intense scholarly discussion because it expanded the understanding of the original intent behind the Reconstruction Amendments, especially the 15th Amendment. Notably, top legal institutions, such as the Harvard Law Review, dedicated special issues to examining the sources from the post-Civil War era that Crockett had brought to light. These sources had often been overlooked or dismissed in previous voting rights cases, but now they gained recognition as crucial evidence that could reshape constitutional interpretation. Commentators and legal experts, including notable originalist scholars, acknowledged the significance of her approach. Professor Acalamar from Yale Law School, writing in a prominent magazine, highlighted that Crockett's work was nothing short of extraordinary. He emphasized that her use of originalist methods vividly demonstrated that the original understanding of the Reconstruction Amendments was far more protective of voting rights than many modern jurists had previously acknowledged. Her method showed how historical evidence could serve as a powerful guide to understanding the Constitution's true intent, especially in cases involving fundamental rights. The influence of her argument became evident even months later when the Supreme Court announced its decision, a ruling that reflected the insights and perspectives she had so eloquently championed. In a remarkable turn of events, a Supreme Court decision was announced with a clear 6-3 majority, a result that underscored a significant shift in the court's approach to voting rights. Chief Justice Roberts authored the majority opinion, providing a comprehensive and carefully reasoned framework for evaluating voting regulations, while Justice Barrett appended a concurring opinion, expressing her agreement with the court's ruling but departing from the majority's reasoning in certain areas. The decision effectively invalidated the challenged voting restrictions that had been under scrutiny, marking a decisive rejection of measures that appeared to impede the fundamental right to vote. Crucially, the court also established a new and more protective standard for reviewing voting laws, a standard designed to ensure that restrictions on voting are scrutinized more stringently than before. When regulations imposed demonstrable and measurable disparities in people's access to the ballot, the majority emphasized, the judiciary must exercise heightened diligence in assessing their constitutionality. As Chief Justice Roberts articulated, in such cases, courts are mandated to apply a more rigorous form of scrutiny, whereby they must verify that the state's legitimate interests underpinning the restrictions are compelling enough, and that these interests cannot be sufficiently addressed through means that do not impose such burdens on voters. This elevated standard, according to Roberts, finds its roots directly in the original intentions and fundamental principles embedded within the Reconstruction Amendments of the Constitution, which rebalanced the delicate power dynamic between state sovereignty and federal authority in safeguarding voting rights. These amendments, enshrined in the Constitution after the Civil War, aimed explicitly to protect newly freed African Americans from discrimination and disenfranchisement, marking a foundational shift in constitutional law. Their legacy, as clarified by the court, necessitates that states do not retain unchecked discretion when implementing voting regulations that substantially hinder access, especially in ways that disproportionately affect marginalized communities. This landmark ruling also featured an unusual development. Justice Alito, who traditionally held a view emphasizing broad state authority in election matters, wrote a concurring opinion rather than dissenting from the majority. Such an occurrence, when a jurist departs from a firm stance and aligns publicly with the prevailing decision, signals a noteworthy evolution in judicial thinking. While Justice Alito reaffirmed the importance of state discretion in managing elections, he also acknowledged that a thorough examination of the historical record, particularly the records derived from the Reconstruction era, provides compelling evidence indicating certain historical constraints on this discretion. His concurrence underscored that, especially in cases where voting regulations impose severe restrictions or significantly diminish access to ballots, states' authority is rightly limited, as these constraints run counter to the constitutional promises of equal protection and voting rights. This nuanced view marked a departure from earlier strict interpretations and was quickly recognized by legal scholars and observers as a seismic shift within the court's jurisprudence. The implications of this decision for voting rights advocacy and constitutional law were immediately profound. Nina Tottenberg, a prominent voice at NPR, described the ruling as perhaps the most consequential recalibration of voting rights jurisprudence in several decades. Legal scholar Richard Hast noted that the case was not merely a win for individual litigants like Crockett, but represented a fundamental change in the national conversation about constitutional protections for voters. For Crockett herself, appearing before the court and making her argument became a defining moment in her already distinguished career. Although she continued her service in Congress, her articulate and powerful presentation during the Supreme Court proceedings cemented her reputation as a formidable legal thinker and advocate for voting rights. Her courtroom performance inspired many, prompting law schools across the country to observe a noticeable increase in applications from women of color, with numerous prospective students citing her example as a motivating factor to pursue careers in law and public service. Sherilyn, the former director of the NAACP Legal Defense Fund, articulated the broader significance of Crockett's demonstration, emphasizing that what the Congresswoman showcased was far more than mere legal expertise. It was a compelling illustration of the power of diverse perspectives in shaping constitutional interpretation. Her lived experience, a Black woman from the South, combined with her rigorous legal training and deep political understanding, allowed her to discern critical historical and constitutional connections that many others might overlook. This fusion of personal history, legal knowledge, and political insight enabled Crockett to illuminate nuances in constitutional history that challenged prevailing narratives and inspired new avenues of understanding. The influence of Crockett's performance extended beyond the courtroom, exerting a substantial impact on judicial ethics and standards. Just 2 months after the argument, the Supreme Court announced a historic development: the adoption of its first-ever binding code of conduct for justices. This code introduced more stringent guidelines for public appearances, mandates on disclosure, and reinforced standards for impartiality and integrity. While no justice explicitly linked these reforms directly to Crockett's hearing, many observers interpreted the timing as indicative of her powerful demonstration of the critical links between public statements, judicial objectivity, and impartiality. Her compelling argument and the attention it garnered are widely believed to have acted as a catalyst, prompting the court to undertake reforms long considered overdue, aimed at enhancing transparency and safeguarding the integrity of the judiciary in the eyes of the public. The ripple effects of her courtroom advocacy extended even further, illustrating how a single, well-articulated legal argument can influence not only the outcome of a specific case, but also inspire systemic change within the broader judicial community, shaping norms and standards that will guide future generations of jurists and public officials. Across states all over the country, legislative bodies started to revisit and reassess their voting procedures with a renewed degree of attention and sensitivity, recognizing that the different ways in which laws affected diverse communities required careful reconsideration. Several jurisdictions took proactive steps to reform their voter identification requirements, aiming to strike a delicate balance between ensuring the security of elections and making the voting process more accessible to a broader segment of the population. These reforms were often justified by references to the new standards set by the Supreme Court, which served as a guiding beacon in shaping these legal adjustments. In the process, many legal scholars with conservative viewpoints initially viewed the approach taken by Crockett with suspicion or defensiveness, as her methods challenged conventional interpretations. However, over time, they gradually came to appreciate that her originalist principles were rooted in a consistent and coherent line of legal reasoning, based closely on the historical context and original intentions behind constitutional provisions. A clear turning point in this evolving legal landscape occurred during a Federalist Society conference held the following year, where the esteemed originalist jurist, Randy Barnett, publicly acknowledged Crockett's intellectual rigor. He emphasized that she had served as a reminder to all legal thinkers that genuine intellectual honesty requires following the historical evidence wherever it might lead, even if this trail ultimately questions or complicates our preferred or expected outcomes. Barnett specifically praised her meticulous research into the original understanding of the Reconstruction Amendments, asserting that her work deserved serious consideration by all scholars engaged in constitutional analysis. The method Crockett employed, relying on comprehensive historical research to shed light on the full context and meaning of constitutional provisions, began to influence mainstream legal practices, especially in the domain of major civil rights litigation. This approach did not remain a niche strategy. It quickly became a standard practice among law clinics at leading universities, which established dedicated projects aimed at uncovering and analyzing overlooked historical materials relevant to a wide array of constitutional issues. For ordinary Americans, particularly those living in communities with histories marked by voter suppression and disenfranchisement, these legal advances carried both practical and symbolic significance. In the subsequent election cycle, voter participation in Jefferson County saw a noticeable increase, with many first-time voters explicitly citing the Crockett case and its principles as their primary motivation for becoming engaged in the democratic process. Crockett clarified that her work was not driven by partisan motives, but rather by a fundamental desire to ensure that the Constitution truly fulfills its highest purpose, namely, safeguarding the rights of all citizens. She highlighted that the core of these rights is the right to vote, which underpins all other freedoms and protections enshrined in American law. When Crockett returned to the Supreme Court 2 years later to present another case, the atmosphere of the courtroom was markedly different from previous encounters. Justice Alito demonstrated respectful engagement with her arguments, and other justices, drawing from her historical research, showed a genuine interest in incorporating her insights into their deliberations. Legal observers noted that the court's entire approach to questions surrounding voting rights had been fundamentally transformed, reflecting a broader legal shift toward valuing historical context and originalist interpretation. As constitutional law professors began integrating her cases and methodologies into their teaching, they often emphasized that Crockett's greatest contribution extended far beyond winning any single legal battle. Instead, her most enduring impact lay in broadening and deepening our collective understanding of what the Constitution truly means. By diligently recovering and bringing to light the voices and intentions of the framers of the Reconstruction Amendments, she had helped restore a fuller, more nuanced vision of America's constitutional evolution, one that acknowledges how each successive generation has worked to expand, interpret, and deepen the promise of democracy. What initially appeared to be a tense confrontation within the walls of the Supreme Court ultimately evolved into something much more profound and far-reaching. It became a potent reminder that the Constitution is not a static document frozen in the year 1787, but a living framework that includes the powerful and transformative amendments, such as those enacted after the Civil War, that continue to shape and redefine the fabric of American democracy. This particular amendment was carefully crafted with the explicit purpose of ensuring that democracy would evolve into a more inclusive and representative form, rather than shrinking into a more exclusive or limited version that marginalized certain groups. It was not merely a win in the context of a single legal debate. It represented a profound step toward restoring and reaffirming a broader vision of equality embedded within the American constitutional tradition. Crockett's victory went beyond the mere act of convincing a panel of justices. She played a pivotal role in reigniting a fundamental constitutional ideal that, over time, had become somewhat obscured by complex courtroom arguments and pedagogical approaches in classrooms across the nation. Her efforts contributed to lifting the veil from a vision of universal suffrage and equal rights that the founding architects of the 15th Amendment would undoubtedly recognize and understand today. The final words she addressed to the panel of Supreme Court justices became much more than a simple closing remark. They transformed into a guiding principle, a touchstone for ongoing debates about how to interpret the Constitution in contemporary times. Her statement served as a rallying cry, reminding us of the original intent behind the amendment and urging us to approach constitutional interpretation with both clarity and courage. The framers who had meticulously drafted and ratified the 15th Amendment would surely acknowledge the significance of what is unfolding in the present day, recognizing the echoes of their work in the current struggles for voting rights and equality. At its core, the question that lingers is whether we, as a nation, possess the constitutional courage necessary to interpret and uphold these principles as clearly and faithfully as those framers did when they first set them down in the founding documents. It is a challenge not solely directed at the 9 members of the Supreme Court, but aimed at the entire country, an evolving society still striving to fully realize and execute the promises embedded within its constitutional fabric. This struggle, rooted in deep historical context, continues to unfold long after that pivotal day, resonating through decades and generations as a testament to the ongoing quest for justice and equality enshrined in the Constitution of the United States.